Welcome to the session on the EPF Classification, Control and Appeals Rules, 1971. In this session, we will cover the key aspects of the rules, including the classification of posts, suspension, penalties, and appeal procedures under the Employees' Provident Fund. This session will provide an overview of important definitions, the application of the rules, classification of posts, suspension guidelines, types of penalties, the authority to institute proceedings, the procedure for imposing penalties, and the appeals process. Rule 3 defines the scope of application. These rules apply to every employee of the Central Board. However, they do not apply to persons in casual employment, those discharged from service with less than a month's notice, or those for whom special provisions are made. Additionally, the central government may exclude specific employees or classes of employees, and any doubts regarding applicability will be referred to the Central Provident Fund Commissioner. Rule 4 outlines the classification of posts under the Central Board. Posts are categorized into Group A, B, C, and D, based on the rank and responsibilities of the employees. These classifications play a significant role in determining the disciplinary authority and the penalties that may be imposed on employees. Rule 5 states that appointments to posts under the EPF are made by authorities designated by the Central Board or the Commissioner. This rule ensures that only the appropriate authority is empowered to make appointments, providing a structured process for staffing under the Central Board. Rule 6 focuses on suspension. An employee may be placed under suspension if disciplinary proceedings are either pending or contemplated, if they are involved in activities that are prejudicial to state security, or if they are under investigation for a criminal offense. If the order for suspension is issued by an authority lower than the appointing authority, it must be reported to the higher authority. An employee is deemed suspended if they are detained for over 48 hours or convicted for a term exceeding 48 hours. Additionally, if the penalty of dismissal, removal, or compulsory retirement is set aside on appeal or review, the suspension continues from the original date until further orders are issued. Where a penalty of dismissal, removal or compulsory retirement from service imposed upon an employee is set aside or declared void in consequence of decision of a court of law and disciplinary authority, on a consideration of the circumstances of the case, decides to hold a further inquiry against him on the allegations on which the penalty of dismissal, removal or compulsory retirement was originally imposed, the employee shall be deemed to have been placed under suspension by the appointing authority from the date of original order. No such further inquiry shall be ordered unless it is intended to meet a situation where the court has passed an order purely on technical grounds without going into the merits of the case. Suspension remains in effect until revoked or modified by the competent authority. If any new disciplinary proceedings are initiated while an employee is under suspension, the suspension can be extended until the conclusion of all such proceedings. Rule 7 lists minor penalties, which include censure, withholding of promotions, recovery of losses caused by negligence or breach of orders, reduction in pay for up to 3 years without cumulative effect, and withholding of increments, with or without cumulative effect. The major penalties under Rule 7 include reduction to a lower stage in the pay scale, demotion, compulsory retirement, removal from service, without disqualification for future employment, and dismissal, which disqualifies the employee from future employment. These penalties are reserved for more serious offences or misconduct. Certain actions do not count as penalties under these rules, such as withholding increments for failing departmental exams, stoppage at an efficiency bar, non-promotion after proper consideration, reversion from an acting higher post, and termination of probationary or temporary employees. Replacement of the services of an employee whose service had been borrowed from an outside authority. Compulsory retirement of an employee in accordance with the provisions relating to his superannuation or retirement. Termination of the services of an employee appointed on probation, during or before the end of the period of his probation. Of temporary employee in accordance with the provisions. Rule 8 outlines the disciplinary authority. The central government, central board, or the appointing authority as specified in the schedule can impose penalties. When an employee is promoted, they are considered as holding the higher post for disciplinary purposes. This ensures appropriate penalties based on the employee's current level. Rule 9 gives the central government and central board the authority to institute disciplinary proceedings or direct other disciplinary authorities to initiate such proceedings. Even if an authority is not empowered to impose a specific penalty, they can still institute proceedings, ensuring flexibility in addressing misconduct at various levels. Rule 10 defines the procedure for imposing major penalties. These include dismissal, removal, or compulsory retirement. No major penalty can be imposed without conducting an inquiry, during which the disciplinary authority investigates charges of misconduct or misbehavior. When an inquiry is to be held, the disciplinary authority must prepare a detailed statement outlining the substance of the charges, a list of relevant facts, and a list of witnesses and documents to support the charges. This ensures that the process is transparent and based on factual evidence. The disciplinary authority shall deliver a copy of charge sheet. Upon receiving the charge sheet, the employee has 10 working days to respond. During the inquiry, they can have a defense assistant, including a retired employee or government servant. This ensures that the employee has adequate support and representation during the inquiry process. During the inquiry, documents are submitted, and witnesses are examined. If the employee pleads guilty or does not appear, the inquiry continues, and provisions for document inspection and witness lists remain. The inquiry authority may return findings of guilt if the evidence supports the charges. Once the inquiry report is submitted, Rule 11 outlines the actions the disciplinary authority may take. The authority must review the report and decide on appropriate penalties based on the findings, ensuring that the process is fair and just. Rule 12 describes the procedure for imposing minor penalties. The employee must be informed in writing and given an opportunity to make representations. If necessary, an inquiry may be held before the penalty is imposed. This ensures due process is followed, even for minor offences. Under Rule 12, 1a, if increments are to be withheld for more than 3 years or if such withholding affects the employee's pension, a formal inquiry is mandatory. This protects employees from severe consequences without proper due process. Rule 15 provides special procedures for certain cases, including situations where an inquiry is not required. This applies in cases of criminal conviction or when an inquiry is not feasible for state security reasons. Under Rule 18, appeals cannot be made against certain orders, including those issued by the central government or central board, or interlocutory orders during the disciplinary process. Appeals are only allowed against final decisions, except in cases of suspension. Rule 19 lists the types of orders that can be appealed. These include orders of suspension, penalties imposed, enhancement of penalties, reduction of pay or pension, and decisions related to conditions of service or reversion to lower grades. Rule 20 outlines the appellate authority. If an order is made by the Central Provident Fund Commissioner, CPFC, appeals go to the central government or the chairman of the Central Board of Trustees. If issued by a subordinate authority, appeals are submitted to the immediate superior. Appeals must be filed within 45 days of the order under Rule 21. Rule 22 specifies the required form and content of appeals, while Rule 23 describes the process for considering appeals. Rule 24 ensures the implementation of orders passed in appeal. Thank you for your attention. This session aimed to provide a detailed understanding of the EPF Classification, Control and Appeals Rules, 1971, focusing on the procedures and penalties that govern employee conduct under the Central Board. For more such videos, visit www.careerproindia.co.in.